This is Bloomberg Law with June Grasso from Bloomberg Radio.
A new dimension to the Federal Trade Commission's challenge to Kroger's $24.6 billion acquisition of rival grocer Albertsons. Kroger has filed a motion in federal court in Ohio to stop the FTC from proceeding against it in-house in an administrative hearing, claiming that proceeding is unconstitutional. Joining me is Bloomberg Intelligence Senior Litigation Analyst Jennifer Rhee. Jen, tell us about the FTC's objections to the Kroger-Albertsons deal.
Well, essentially the FTC is just saying this is a merger of two competitors. And in a market that the FTC has defined, which is somewhat narrow, I think that'll be a point of contention in the trial. But they say these are traditional grocery stores, one traditional grocery store buying another, and they really only compete with other traditional grocery stores. So that leaves out specialty grocery and club stores like Costco. And that in many, many regions in the United States, this merger will end up leaving markets that are overly concentrated. When they're local markets, like grocery, because people aren't going to drive hundreds of miles just to go grocery shopping, it's like thousands of little mini mergers that have to be assessed across a map. And they look at these regions where both stores compete, and they look at who the other competitors are in the region, and they draw circles around the ones they think will be too concentrated. And here they say, look, too concentrated in many, many regions. And even though the companies have offered to divest stores in quite a few of these regions, the FTC says not good enough. It doesn't fix some of the other concerns we have about the impact on labor. And also, we are not in love with the buyer who you've chosen for these stores. We are not so sure that buyer can take these stores and be a viable competitor. And that's what's needed in a divestiture remedy.
So the supermarkets propose to sell nearly 600 stores and lower grocery prices by $1 billion. How is that going to work?
Well, that's the thing. Promises to lower prices or promises not to increase prices don't really hold much water. The FTC is not going to be a pricing regulator, so they're not going to put something like that in a consent agreement to say you must price at X or you must lower your prices by X, Y, or Z. And when the companies make promises like that, that's all they are. There's nothing the FTC can do to hold them to that. So it doesn't really mean very much, even though the companies very well may have every intention to do that.
The trial is set to begin on August 26th. Is that an in-house trial?
No, so that trial is in a federal court in Oregon, and this is the Federal Trade Commission only seeking a preliminary or a temporary block on the closing of the deal pending their in-house process, which is called a Part 3. Basically, it's an administrative law hearing to actually determine if the deal is illegal or not. So this is just to seek a preliminary block to allow the FTC to complete that internal process, which takes quite a long time. It could be another year before, if they actually go through with that internal process, it could be another year before there's a decision there.
So now Kroger sued the FTC. It's not about the preliminary injunction. It's about trying to prevent the in-house process. So explain why they say the in-house process should be blocked.
So this is something new that's happening in these merger deals in front of the FTC, and it's all because about a year ago, there was a Supreme Court decision that opened the door to constitutional challenges to that in-house process. Companies have always objected to it because it really basically kills deals because they take too long. So when companies don't win at the preliminary injunction phase and they have to face this internal process, a deal can't last and the deal tends to fall apart or get abandoned. So there's always been objections, but in the past when companies have said this is unconstitutional, what the courts have ruled is that, well, you have to bring that claim in this process, in the administrative process, and then you'll have an opportunity to appeal to the federal courts and get to the federal courts after that. Well, that doesn't work. That hasn't worked in the past because that's too late. The deal's already been abandoned or broken up. But last year, the Supreme Court said, no, that's incorrect. These companies have the right to challenge the constitutionality of the process in a federal court early on before the process has even started. So what that's led to, June, since that decision, really, many deals that have been challenged have actually brought these counterclaims alleging that this internal process by the FTC is unconstitutional. Now, not many of them have gone very far, because either the companies won at the preliminary injunction, they closed their deal, the litigation got dropped, or, let's say in the case of Amgen and Horizon, the FTC settled the matter, and when they settled the matter, the companies dropped their constitutional claims. So there's not a lot of precedent. And the only thing in that case, that particular merger that the Supreme Court did decide, was just that procedural timing issue, that they have the right to bring these arguments. So Kroger and Albertsons have gone ahead and done that because they can, and they are making an allegation that there are two different reasons that that process is unconstitutional. One having to do with the administrative law judge who will decide the outcome, having two layers of for-cause protection from presidential removal, and they say that violates one article in the Constitution. And the other argument is that this is an adjudication of Kroger's private rights. They say it's Kroger's contracting rights, which is a private right, and when a private right is adjudicated, the Constitution says it must be in the judicial branch and not in the executive branch.
The case that you were referring to, was that a case involving the FTC or the SEC?
So that was a case actually involving the FTC, not as well known as the SEC case, which is called Jarchese and was talked about a lot. This was a case called Axon. Axon was acquiring a company called ViView, and that case ultimately settled. So what happened there was the Supreme Court decided the one element that I mentioned, that timing was okay, that the companies can bring this challenge before the administrative internal hearing has even started. But on all the other constitutional claims, which were similar to the claims Kroger's making, the Supreme Court remanded to the district court and say, okay, you have to decide on these claims. But then they settled. So those claims never got decided on. The Jarchese case, which involved this Securities and Exchange Commission, decided that where a plaintiff is seeking monetary civil penalties or monetary damages, that the defendant has the right to a trial by a jury. So that automatically would pull a hearing out of an administrative agency and put it in the judicial branch in a court.
Kroger sued in Ohio. Why in Ohio?
Well, I think they sued in Ohio because that's where Kroger has its corporate headquarters. So that's why they picked Ohio. It is the Sixth Circuit, and we don't have precedent there. They may expect it to be a conservative circuit like the Fifth Circuit. That's the one place where we do have some precedent that would be helpful to them. I'm guessing they believe that they'll get helpful precedent from the Sixth Circuit, too.
Well, shouldn't they have sued in the court that's holding the preliminary injunction in Oregon?
Well, they may believe that that's not the best place for them to sue, and they can sue wherever they're doing business.
I just wondered if the government might move to remove the suit to the place where the case is being litigated.
They may, but I doubt that they'll get it transferred. I mean, they had the right to bring it in Cincinnati, and I don't think they would get it transferred over there. And I think now that I think more about it, that it's definitely that they're not all that happy with the pickup judge there, and they think they might be better off in front of a Sixth Circuit Ohio judge.
So Kroger said that in the lawsuit against the FTC, it said that in-house review could take years. Is that an exaggeration, years?
You know, June, it really isn't, and I'll tell you why. Because the FTC subtly changed something also about 2 years ago. It used to be that the administrative law judge would write a decision, and then the loser of that decision could appeal to the commissioners, and the commissioners would vote, and then the loser of that process could then appeal to the federal courts. But the FTC changed it, and they said the ALJ no longer issues an opinion, they just issue an advisory. Here's how they think the FTC should rule, and then the commissioners decide. Well, if you look at this situation, these are the very commissioners that voted to sue Kroger and Albertsons to begin with. So we know how that's going to come out, right? And that whole process, given the timing that is allotted in the rules, the FTC's rules, can take about a year and a half. And it wouldn't be until that time that the commissioners actually issued a final decision that the companies could appeal to the federal courts.
I mean, is there a drop-dead date on this merger?
There is, but I think it's going to be changed. It's October 5th or 6th, something like that. But at this point, the companies are going to have to push it back because they made an agreement with a Colorado state court. I should mention there are separate proceedings going on in both the Colorado State Court and the Washington State Courts, brought separately by the attorney generals of those states. And in the Colorado court, there was going to be a preliminary injunction process and a permanent injunction process. And the companies convinced that court to do it all in one in just a permanent injunction process, but the only way they could get that was by promising they wouldn't close the deal until a decision had been issued on that. And that's not going to be done until about the middle of October.
So they're facing basically 5 separate legal challenges. Do they have to win them all for the merger to go forward?
I don't think so. I think that the state court judges, in my view, are going to be nervous about the idea of enjoining, let's say they want to rule for the AGs, of enjoining a nationwide deal that the FTC can't manage to enjoin in federal court. So let's say the parties win on this preliminary injunction process that's starting later this month. I don't think those state AGs would go against that. They may enjoin it just for their state, but not nationally. So I think the most important thing happening here is this preliminary injunction process in Oregon, which will be the very first one to start and the very first one to get a decision. There is also a private lawsuit. My guess is that'll ultimately settle. But my guess is also that it won't be successful if the FTC is not successful. So I really think if they can be successful in the preliminary injunction process, they'll probably ultimately down the road be able to get it closed.
The private lawsuit, a group of consumers sued over the deal last year. That was unsuccessful, right?
Right. I have to check that suit. You know, these suits are brought all the time, and they're honestly never successful. Never. Because these judges are just going to stay these matters and wait to see what happens in the federal government
I
suit.
see.
Right? So I believe that matter at this point is stayed, but I don't think that matter is ultimately going to impact whether this deal closes or not.
I mean, is antitrust a red-blue issue? Because Republican attorneys general in Ohio, Iowa, Alabama, and Georgia slammed the challenge, saying it was devoid of economic justification. And they filed an amicus brief in Oregon.
It used to be more of a red-blue issue than it is today. I think there's a wing of the Republican Party that actually is aligned with the idea of aggressive antitrust enforcement and has liked what Lina Khan has done. It doesn't surprise me, though, that for the amicus brief, there were no Democratic states attorney generals that joined, because I think for something like this, probably it is a little bit more of the business-friendly approach versus the, anti-big business approach.
Does the FTC have a good case?
I think the FTC has a good case in terms of the buyer that's been offered up for the remedy has some weaknesses, and one can't be particularly certain or feel comfortable that that company will actually be able to compete or even has the incentive to compete with those 600 or so stores for many years or even in the short run. Where I think it gets a little more difficult is with market definition, because the markets have changed a lot over the years in grocery, as they have in many, many goods that you can buy now online all over the place. And the FTC is using the same market definition they have used for years for grocery deals. They've not changed it at all. But things are a little bit different today, and they may have defined the market a little narrowly. The judge could agree that other stores should be included, such as Whole Foods and health food stores, stores like Trader Joe's, dollar stores, Costco. All of these stores have been excluded. Walmart and Target have been included where they are supercenters and sell groceries. And if the judge agrees that the market should be a little broader, what that will do is reduce the number of regions in which this deal is considered anti-competitive and reduce the number of stores that might have to be divested. And possibly, if this number of stores that have to be sold is reduced, it may be a package that would be more manageable for this buyer. I will tell you I still lean toward the FTC winning this case, but that would be the argument on the other side, and it is a defensible argument.
Kroger sold $10.5 billion of notes yesterday to fund the acquisition. They think that they're going to be successful.
Obviously, they do. I have to tell you, I was a little bit surprised by that. I mean, especially given with all of the lawsuits that are pending against this deal, and the fact that it looks like the FTC pulled a pretty good judge, and it will take some time. If the companies lose this preliminary injunction and appeal, that's going to take quite a lot of time, and it means that this deal is going to have to hang together for another 6 months to a year in order to get that appeal decision, if that's where they think they can win. So I was a little surprised by that.
This may not surprise you. Kroger and Albertson have so far spent more than $800 million in fees on lawyers, bankers, and advisors. $800 million.
That is so much.
The deal's $24.6 billion. I mean,
I know. Well, that's a lot of money. when I practice law, it's definitely far more than I think the defense of many of the deals that I worked on. I will say, as we mentioned, they're facing 5 lawsuits. And so that's possibly part of the reason. They need huge teams. It's taking a lot of time, a lot of attorney hours. It's taking a lot of work. And most deals face, if it's DOJ, they face 1 lawsuit because the DOJ just goes to federal court and seeks a permanent injunction. Or if it's FTC, they're just facing 2. They're facing the preliminary injunction effort and then the internal trial called a Part 3. So I think that's part of the reason these fees are so exorbitant.
So we'll see what happens. I mean, it seems like we've been talking about Kroger-Albertson's for years. And now that I look it up, I see that we have been talking about it for nearly 2 years. It was first announced in October of 2022.
I know. I'm guessing a decision's going to be coming out some point in October, maybe toward the end of October. That's just a guess because judges don't really have time constraints on their decisions, and we now know the companies have agreed not to close until this Colorado process is over, which takes a little bit of the pressure off the judge because they tend to try to decide before an end date for a deal. So I'm thinking sometime around the end of October.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Bloomberg Intelligence Senior Litigation Analyst Jennifer Rhee, and we'll discuss the FTC's first attempt to block a fashion accessories deal. I'm June Grasso, and you're listening to Bloomberg. So let's go from groceries to something that I find more interesting.
Yeah.
Luxury handbags or semi-luxury handbags.
Yes.
So this marks the first time the Biden administration has intervened on antitrust grounds in the fashion accessories sector. Tapestry, the company behind Coach, Kate Spade, and Stuart Weitzman, would acquire Capri, which controls Michael Kors, Versace, and Jimmy Choo, in a deal valued at $8.5 billion. Tell us more.
So this, just like the Kroger-Albertson's deal, is really a basic deal that combines 2 competitors, what we call a horizontal deal, the typical type of deal that's often challenged by the antitrust agencies. And one of these companies has the Kors brand and another has the Coach and Kate Spade brand. And what the FTC is claiming is this creates too much concentration in a market that they're calling affordable luxury handbags. So they think of a Kate Spade bag and a Kors bag and a Coach bag to be in this segment. They haven't defined it by dollar amount, but they've defined it just by calling it affordable luxury. And just like Kroger and Albertsons, I think that's where the big fight's going to be in this trial over this market definition, because it's a hard market definition to put the boundaries around. What exactly is an affordable luxury handbag? Who else is in that market? What is the competition? And that's obviously really important to determine what the market concentration will be after the companies merge. What is included? Would you include, higher level designer bags that are sold used for a lower price? And I think that's going to be a difficult part for the FTC. Now, having said that, they issued new merger guidelines last year. And what they've said is, hey, we no longer have to define a market where we can prove that the companies are each other's primary competitors. And if they really just view each other as each other's main competitor and don't pay that much attention to others, that's good enough. And that's what they're claiming here. They're saying that in their investigation, all the documents they collected support the idea that these companies really don't pay attention to other competitors. In other words, their price isn't constrained by other competitors. That's how the judge will look at it. That's how economists look at it. Only by each other, particularly in outlet malls. So if one goes on sale, the other goes on sale. If one raises their prices, the other raises their prices. And what they're going to claim is that this is good enough to show that you lose that entire rivalry, that entire competitive dynamic, if you allow these 2 firms to merge.
So that's a rule that they made up.
Yes.
So, hello, are judges following that rule?
You're exactly right. These are guidelines written by the FTC, and what they're meant to do is tell the market how they're going to look at these deals and also to help guide a judge, but they don't bind a judge. So the past merger guidelines, the judges usually use them. They usually say, align with them, here's what the merger guidelines say, and so we agree. They don't have to. And so this will be very interesting because we just don't have a lot of precedent. We don't have litigation yet where the FTC's tried to use these new guidelines and get a judge to accept them, and it's up to the judge, and they may not.
My initial reaction is, why block a fashion deal? It's not like there's no competition in the fashion industry.
Well, this is exactly what the companies are arguing. Hey, we have so much competition.
And there's easy entry into that market.
That is exactly what they're arguing, that there's easy entry, that we always have to worry about entry because one influencer carries some mom-and-pop bag and that bag will blow up. And that's what they're going to argue. And I think it's a pretty good argument, honestly. A lot of times people ask, why would the FTC or DOJ challenge this deal? That industry is not that important, or that's not a crucial industry. People don't have to go out and buy a luxury, affordable luxury handbag. That's not how they think of it. They're looking at any industry in which a merger would create undue concentration. It doesn't matter if it's affordable luxury handbag or it's essential like food. If they believe the antitrust laws are being broken by a deal, they're going to challenge the deal. And that's what they believe here. And as you said, this is really going to be about the market and how it's defined and who competes and who doesn't and how easy entry is, because I think a lot of people view the market that way, and we're very surprised by this challenge.
And affordable luxury is almost a contradiction in terms.
I agree with you.
If it's affordable, then you don't consider it really luxury, do you?
Yeah, exactly. The interesting thing is the parties, and I don't blame them at all, very early on, right after this lawsuit was filed, asked the judge to require the FTC to provide a better definition. Exactly what do you mean by affordable luxury? Put the boundaries around it. What are the dollar amounts and who are the other competitors? And I think it was a reasonable ask, because they need to defend themselves. And the judge said, no, that's the kind of thing that can come out in the hearing.
Now, what happens next? There's a trial? Is that in-house?
Yes, so there is a trial. Just like the Kroger-Albertson deal, there's a trial in federal court. That's in the Southern District of New York. That'll be starting in September. That's on the preliminary injunction. And then there is a Part 3. That's the internal hearing that would start toward the end of September. The companies asked the FTC to push the date back. It used to be customary that the Part 3s were always pushed back so that the preliminary injunction could be decided first, because there's no point in trying a Part 3. If the companies lose the preliminary injunction, they usually abandon the deal. So why waste the time starting the Part 3 when that's usually what happens? You want to wait and see what happens in the preliminary injunction, but here the FTC said no. And June, so interestingly, they did the same thing with Kroger and Albertson, and that internal process was supposed to start July 31. But the administrative law judge, who is the chief ALJ, the acronym for administrative law judge, and who actually is aligned with the concept that the Part 3 should get pushed back or stayed pending the preliminary injunction, used his own powers that he has as ALJ to say, we will start on July 31st, but we're going to do the introductory notices of appearance on the record, and then I'm going to stay the entire trial until the preliminary injunction process is over.
Interesting.
The commissioners have to decide whether to push back the start. He couldn't do that, and they ruled against that. But what he could do is stay the trial, and that's what he did. I don't know that the administrative law judge that's overseeing the Tapestry-Capri deal, who is a new administrative law judge, will do the same.
Who do you think has the advantage in the Tapestry-Capri?
I think that one's really close. My gut reaction to it was exactly like yours. Oh, come on, this is a really competitive market, and how do you really define that market? I mean, this is this big span of pricing, and some people will buy a lower-end bag and some a higher-end bag, and you can buy used designer bags for those prices, and that was my initial reaction. But, what was telling is that when the FTC voted to sue, it was a 5-0 vote, meaning the two Republicans also voted to sue. And one made a statement that she did so based on the evidence she'd seen, showing that these two companies were each other's primary competitors. And that means to me there are probably a lot of documents that support the FTC's case. So I'm very much in the middle on this one. I will be going to trial, and I'll have a better feel after the trial. But I'm really 50-50 on it.
Please come back after the trial, Jen, and describe what an almost luxury handbag is and how much it costs. Before you go, let's talk Google and the remedies that are possible there after that landmark decision that Google is a monopolist. Google said it will appeal the decision, but Judge Amit Mehta has ordered both sides to begin plans for the second phase of the case, which will involve the government's proposals for restoring competition, including a possible breakup request. So the judge has asked the Justice Department and Google to come up with a process for determining a fix by September 4th.
Yes.
So, what is the Justice Department considering here?
Oh, I think they're probably considering all options and probably even getting creative. coming up with things I'm sure I haven't come up with. But they won, and they won, I think, based on the opinion, fairly resoundingly, right? So I think they will definitely seek some sort of a structural breakup of the company. That could be breaking off Chrome, it could be breaking off Android, it could be breaking off a product that Google has that's called AdWords that basically is used for selling the text advertising that comes up on a search page when you do a Google search. It could be any of those three that they seek. They could ask to ban the agreements that Google has, or the payments, I should say, that Google makes to browser companies to set Google search as the default, and the payments that it makes to Android phone makers to install the Google search widget, front and center, and not install competitors' search widgets, and any other kind of agreements it has with other companies to install Google search as the default at key access points to the internet. I think they might also ask for something called like a choice screen. Somebody buys a new Android phone and they set it up. You have a choice screen that allows them to pick which search engine they want to set as their default rather than the phone just coming with that default already set. And I think also they may try to require Google to provide some of the click data that it's developed, collected over the years through the millions and millions of searches that have been done, because that is how its search engine has improved. At least that's what the judge decided, that it was that search engines, to get good, need scale, and scale comes from a lot of searches being done because that improves the search engine because it learns from every search. And the rivals like Bing and DuckDuckGo weren't able to develop in the same way because they were pushed out of the market by all of the default positions that Google had paid for. So it may be that the DOJ asks for data to have to be shared with these rivals to allow them to try to improve their search engines.
It's going to be so interesting to see whether, despite all these fixes, people still want to Google. It is a verb after all. Thanks so much, Jen, for taking us through all this antitrust. That's Bloomberg Intelligence Senior Litigation Analyst Jennifer Rhee. Turning now to other legal news. The Pregnant Workers Fairness Act has been more than a decade in the making. It was first introduced in Congress in 2012 and reintroduced in almost every legislative session. The act finally passed with bipartisan support in December of 2022. But Texas Attorney General Ken Paxton sued the Biden administration last year over the massive government funding package that passed largely by proxy votes due to the COVID-19 pandemic. Paxton focused on the PWFA in particular, saying that it put an undue burden on the state government to accommodate its pregnant employees. And then in February, a federal judge in Lubbock, Texas, ruled the PWFA was unenforceable against the state government. That ruling is now being appealed to the Fifth Circuit Court of Appeals. Joining me is Dana Bolger, Senior Staff Attorney at A Better Balance, the Work and Family Legal Center. Tell us about the Pregnant Workers Fairness Act.
The Pregnant Workers Fairness Act is a new federal law that requires employers to provide pregnant and postpartum workers with reasonable accommodations, such as more frequent bathroom breaks or excused absences to get prenatal care or even to rush to the emergency room for a pregnancy-related complication. And before the PWFA, pregnant workers across the country had no affirmative federal right to accommodations like these for ordinary pregnancy needs or even for serious pregnancy complications. We had the Americans with Disabilities Act, which similarly provides reasonable accommodations to workers with disabilities, but again and again, courts were telling pregnant workers, you don't have a disability, so you don't have a right to reasonable accommodations. Our organization, A Better Balance, runs a free legal helpline, and on that helpline, we were hearing from hundreds of workers who were being denied even really basic accommodations that they needed, like a stool to sit on during the day. One worker, Rebecca, had to occasionally do heavy lifting at work. And during her pregnancy, she had asked not to lift, but her supervisor refused and told her that if she didn't, she would lose her job. That put her, like so many of the other pregnant workers that we were hearing from, in the impossible position of choosing between jeopardizing her health or losing her income. And she ultimately kept lifting and miscarried shortly thereafter.
It was first introduced in 2012, and then it was reintroduced in almost every legislative session. after that. Why did it take so much to get this passed?
This is a workplace civil rights law. I wouldn't say that it's every day these days that Congress is passing workplace rights laws, but it was over the course of years and years of work that our organization and others was able to bring on board organizations like the Chamber of Commerce. The Chamber actually became a big champion of the Pregnant Workers Fairness Act. It actually added the law to its congressional scorecard so that Congress people who voted for the PWFA would be scored positively for doing so. And just generally bringing along the business community on this law became a huge asset. Businesses came to support the law because it provided a consistent national standard for what they should do when a pregnant worker needed an accommodation. It provided really key predictability to businesses, and it helped boost employee morale and retention too.
Did Texas attack the entire statute?
Texas sued specifically over the Pregnant Workers Fairness Act, but the PWFA, as you're alluding to, was passed as part of this massive $3 trillion Appropriations Act, which included other pieces of permanent legislation, not just the PWFA. And Texas's argument and the district court's ultimate holding said that Congress passed the entire act unconstitutionally, not just the PWFA. So the implications here are really far-reaching.
And explain why the judge said that it was passed unconstitutionally. What happened during the passage?
So the district court held incorrectly, in my view, that the Constitution requires a physically present majority or a physically present quorum to vote on legislation. Congress passed this massive Appropriations Act using a COVID-era voting rule called proxy voting. And under that, a House member could designate another House member to vote for them while they were not there because of the public health emergency. And so when the act was passed, a number of House members voted via proxy, and the district court said that that was unconstitutional and basically read into the Constitution a physical presence requirement that simply isn't there.
I take it that other acts were passed in the same way during the COVID era.
A number of other acts were passed over the couple years that this proxy voting rule was in place, but never with so many members voting via proxy that there wasn't a physically present majority there to vote on it. So this massive Appropriations Act was a little bit unique in that so many people were voting via proxy at that time. But I think it's really worth pointing out that the number of House members that participated in this vote, it was 99% of House members. I mean, a huge participation rate. So this wasn't a situation where some tiny fraction of members were voting. This was a rigorous voting process that many people participated in.
Give us a little information about the judge.
Yeah, it's Judge Hendricks. He's a Trump appointee. The political valences of this case, I think, are actually quite interesting. He's a Trump appointee, and, Texas is obviously no friend of the Biden administration, but a really broad range of stakeholders weighed in amicus briefs in this case last week. So Mitch McConnell, of all people, certainly no friend of the Biden administration and also not a feminist firebrand in any way, actually filed a brief in support of the Pregnant Workers Fairness Act.
That is surprising.
Arguing, so he actually voted for the PWFA, which was an overwhelmingly bipartisan piece of legislation. But more than that, Senator McConnell objected to the court's intrusion in Congress's authority to set its own voting rules and procedures.
So was this decision a novel decision?
As far as I'm aware, this is the first time that the proxy voting was addressed by a judge in quite this way. House Republicans actually did challenge the proxy voting procedure back in 2020 when it was adopted, and the D.C. Circuit ultimately rejected the case, but on different grounds.
So now what happens now? What's the next step?
Briefing at the Fifth Circuit should wrap up in the next couple months. We expect oral arguments and that the Fifth Circuit will then decide the case.
The Fifth Circuit is the most conservative federal appellate court in the country, and we saw how many of its cases were overturned at the Supreme Court this past term. Are you confident that Judge Hendrick's decision will be overturned, or are you concerned?
I mean, I'm certainly hopeful that the Fifth Circuit will look at, frankly, all the really unlikely bedfellows who came together in amicus support in this case to raise the alarm, and that they'll reverse the district court's decision. It's worth noting that in addition to Senator McConnell, a group of bipartisan former high-ranking national security officials actually filed an amicus brief in this case as well. And they argued that the district court's novel reading of the quorum clause to require physical presence could actually hamstring our national security at moments when, for example, D.C. is under attack, or there's a national public health emergency, or air traffic is shut down. And it's at those moments of attack on the United States that Congress actually most needs to act and shouldn't be paralyzed from doing so simply because all the members can't physically convene together in a single location.
Now, the court's injunction, does it just apply to the state of Texas?
Exactly. It says that the EEOC and the Department of Justice cannot enforce the Pregnant Workers Fairness Act against the state of Texas. So essentially, it's really weakened quite profoundly the rights of Texas state government employees to relief under the Pregnant Workers Fairness Act. But it's important for pregnant workers across the country elsewhere to know that their rights are very much still in place.
I've lost track of how many times Texas has sued the Biden administration.
Yeah, Texas has certainly taken the lead in trying to attack the rights of workers across the country, including pregnant workers. I think it's really notable here that so many conservatives themselves have aligned against Texas in this suit. I mean, first of all, you don't have any other states' attorneys general joining Texas in this case, which is quite striking. And then, of course, you have Senator McConnell and, former national security officials that served in Republican administrations saying, whoa, stop. This is extreme. This will hamstring the federal government. This case needs to go.
Thanks so much, Dana. That's Dana Bolger, Senior Staff Attorney at A Better Balance, the Work and Family Legal Center. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.